Good morning, everyone. I'm Ann Wolf. I'm the Education and Events Director of the Contra Costa Bar Association. And I wanted to welcome you all to our program this afternoon with Bob Jacobs. I wanted a few housekeeping items. Your materials and the attendance certificates will be sent out a few days after the program. And I'm going to, if you have any questions, Bob, how did you want to take questions today? We didn't discuss that.
I typically haven't had a lot of questions,
Okay.
but everyone can send them on the Q&A feature on the toolbar
Great.
on the bottom of the screen, or we can do them at the end, either way.
Okay, great. I'll be monitoring the chat as well, a little bit here and there. So, but first, let me begin by introducing our speaker. This is Bob Jacobs. Bob has been litigating for more than 30 years, and he now mediates business, real estate, trust, and probate cases. And in 2020, he served as the chair of the Contra Costa County Bar Association ADR section, and was co-chair of the Alameda County Bar Association ADR section. He is a designated super lawyer and holds an AV rating with Martindale-Hubbell. Since 2017, he has served as one of the update authors of the CEB treatise, Real Property Remedies and Damages. In 2021, he will be rewriting its chapter on ADR. He's received his mediator training from Northwestern University in Chicago, Illinois. Bob, I'm going to turn the program over to you.
Great. Thanks, Ann. Welcome, everyone, and good to be here with you today. I'm going to share my screen, and most of this program has been committed to this PowerPoint program. So I'm going to follow it pretty closely and with additional comments. And then these slides are going to be emailed out to you after the program is over by Ann. So you don't have to take any particular notes unless you choose to, but the slides will be made available. All right, you should see the slide on your screen, 5 keys to mediating with power. Here's the background, the bio, the disclaimer. I send out a monthly newsletter by email. If you have an interest in being put on the list, just send me an email afterwards at this address and I'd be happy to add you. Here are the 5 mediation PowerPoints that we'll be talking about today. And you'll see a lot of these are self-evident, but even though they're self-evident, they still bear repeating and focusing on because they come up so consistently. Number 1 is marshal the logistics. Number 2 is get what you need. Number 3 is get the other side what they need. Number 4, get the mediator what they need. Number 5, work effectively with the mediator. And we'll talk about these in that sequence. So number 1, I call this mediating without power. And this is the case of the opera tickets. This was a case where I was serving as counsel, not as mediator, some years ago. And it was a heavily litigated case. By the time I was done with it, it had been litigated for 20 years. And as we all know, when you're done with a trial or a dispositive motion for summary judgment, all the proceedings after that are subject to appeal. I have a right of appeal with them, which means that if you have parties who really want to litigate, they can do so for an awfully long time. And this was one of those cases. It had been litigated for 10 years before I got it, and then I litigated for the second 10 years. And then we did several trials and appeals, several appeals, and then it went off to other counsel. We were at this, one of the stages of appeal, and the Court of Appeal at that time had a mediation program, and we were referred to it. And we showed up at the mediation, and we mediated all day. And this case had been going on many years by this point, and there had never been any just breath or hint of settlement. We got to a point late in the day, and I could start to see that it looked like a settlement was going to come together. I could feel it, I could see it, I could sense it, I could almost taste it. We were almost there. And lo and behold, at about 5 p.m., The mediator says, we're making good progress, but unfortunately, I have to go. My wife has purchased opera tickets for tonight, and I just can't let her down. And at first I didn't think he was serious, but then I realized, no, he meant it, and he left, which put an end to the mediation that day. Even though it felt to me like within a hair's breadth. After that, things fell apart. We finished up the appeal. We went back down to the lower court. We had another trial. It went on from there. But it was one of those cases. We all know a lot of times a case may not settle at mediation, and then the parties sort of go back to their respective corners or offices and then work something out on the back end. That's not always the case. And this is one of those situations where it was not the case. So my question here today is, what's the fastest way to end a mediation unsuccessfully? And the fastest way that I know of is to have a key player leave, because there's just no way to negotiate around it. You can't soften it. You can't deal with it. It's so final for mediation if one of the key parties leaves, a party or the mediator. It's just the end for the day. So the first point of power is to marshal the logistics. And for my money, the single most important thing is to make sure that all the necessary people participate. That may seem self-evident, and in many cases it is, but sometimes it's not. So that would be all the necessary people. That would be all the necessary decision makers. And they may not all be parties. So you can have influential non-parties that are going to make a significant difference on whether a case is going to settle, such as influential family members or significant others, or sometimes even key friends. And if they're not going to participate all day in person or by Zoom, then it's really important that they be available by phone. Sometimes people come into mediation, they think, well, I know what this person's perspective is, or the case isn't going to settle anyway. And so they don't always make arrangements to have those key decision makers available by phone or otherwise. That can be a problem if you don't have a key person available, or of course, if somebody has to leave. It's important to have all settlement agreement signatories. So you see this sometimes when maybe you have a couple that are aligned and they have a common claim, and for one reason or another, someone can't participate that day, and so the one person shows up. Ideally, both parties, both plaintiffs or both defendants, are going to show up in person. But if it just cannot be, then sometimes one of them may show up with a power of attorney. That may or may not be acceptable to the other side. But if it has to be that way, then it goes without saying, but is still important to make sure to bring the power of attorney, so that you can try to give some assurance to the other side that if a settlement agreement is signed, that the party signing truly is authorized on behalf of the other side to do so. It's really worth the time to spend thinking about potential cross-defendants. This happens, I find this happens on an ongoing basis, that there are potential cross-defendants that either may not have been fully identified, or they've identified and they haven't been invited to the mediation, but they may help fund the settlement. They also, in exchange, they buy peace, and it's tempting sometimes to answer no for them in advance if they aren't required to be there at the mediation. So a good example is the California Association of Realtors standard purchase contract. And the parties are required through a mandatory mediation provision to show up, or at their peril lose the ability to recover attorney's fees if they prevail at trial or arbitration. There have been some dramatic cases where that actually happened, where somebody declined the invitation, if you will, to attend mediation, went all the way to trial, won, had huge attorney's fees, and then were denied the right to recover them. The Fry versus Davy case is one of those. It was over $500,000 all told with attorney's fees, with a declining by the one side to participate, who then won after binding determination and lost the right to fees because they hadn't participated. So there's a heavy hammer available for the parties to participate in mediation. That's not always the case with other parties who may be involved in a real estate transaction or otherwise. That can be brokers or inspectors or other people who may have been a party or might be a potential cross-defendant. It's very tempting to say, golly, these people never show up. My primary dispute is with the other side, the buyer, the seller, or whoever the other contracting party is. It's not only in those CAR forms where you find these mandatory mediation provisions, it's in other contracts as well. Very, very tempting to think, they're not going to be here, but they can help fund the settlement and they buy peace. Sometimes they show up and they won't contribute much. Sometimes they show up and they contribute substantially. So it really depends. Lay the groundwork for full participation. So make sure that you have your clients over whom you have the most control available the entire day. And I always encourage people to leave open their evenings. It's, I think, human nature to want to double schedule or take advantage of time. And we think a mediation is going to be done by a certain amount of time or a certain point in the day, or it won't be done at all. And so, we'll have an idea then, and maybe I can schedule something else in the afternoon or evening. And I see this now and then. So, it's possible for someone to schedule airline flights if they have to be somewhere. And I had a situation once where someone said, after the mediation schedule, they said, well, just to let you know, I've got airline flight at 4:30. I have to leave by about 3:30. And what else can you say as a mediator? It's like, well, it might be done by then, but if it's not, you're guaranteeing that it'll be done, at least with respect to your side of the case if you leave. So if there's any way that you can reschedule these flight arrangements, I very much urge you to do so. And I've had that situation where someone said that after everything's set, schedule the flights. And then I said to him, look, are you sure you really want to do this? Everything is going to have a climax on this day. And they rescheduled. And we did get the case settled, but it wasn't until the early evening. If they had left early in the day, never could have happened. So maybe we would have come back on another day, maybe not. Maybe parties would have gone off to litigation and spent tens or more than that of thousands of dollars in attorney's fees and then mediate again later. But if you can be there without a hard stop, it's so valuable. Childcare issues can be significant. If you've got people with children at home and they've made childcare arrangements for a certain day, or a certain time, but they haven't made any arrangements for after. If you're right in the middle of it, and you can feel it and you can see that a resolution is about to happen, and then someone says, well, I have to go, I've got childcare, and there's no backstop, that can just bring a sudden end to what's going on with your mediation that day. And then, of course, tickets, opera, ball games, other things we've talked about. In our current COVID situation, it's not really very important to have secure meetings that are available without a hard stop, because so many people are doing this remotely. But someday we all anticipate that's going to end. And certainly pre-COVID, it was valuable to have meeting facilities that are fully available for as long as need be. I've had situations, maybe at a courthouse, where frankly, the court most times just doesn't care. It's like the deputy shows up and says, and it's 4:45 and you need to be out of here in about 5 minutes. And they're just not going to facilitate some further settlement discussions. And so in that case, I've gone to counsel's offices where we finish cases. We've gone to restaurants in the months when there's good weather outdoors and finish them. You do what you have to, but it's certainly available, and you don't lose any momentum and certainly any time. If when you're setting up the facilities, if you can set something up, if at all possible, that doesn't have a hard stop with it. You want to prepare for a day that's free from technical issues. This may sound like just a no-brainer, but it's not. Things happen, even especially in this COVID era, even with people who are regularly doing things remotely can have problems. So, I had a case once where what I try to do to address this is, in front of most mediations, I try to schedule a meeting with the parties and their attorneys by Zoom, so that way we know that everyone's equipment is working. Sometimes there can be these audio problems, or sometimes people don't have sufficient bandwidth, or sometimes clients are not very techno savvy and they can't navigate their screen and get around and get into the session. or they don't know how to to send an email that would include a scan of maybe like a settlement document. So we try to do that in advance, and I've seen it, you know, where maybe counsel is on all the time, but there's a software upgrade to their office or to the computer, and all of a sudden they have technical problems that they've never had before. And we've discovered those, you know, and we've done these pre-mediation technical meetings that don't have to be long. So it's really great to check out the camera, the microphone, the speakers. If the audio is bad, it's so difficult. You're already working so hard to try and understand what the parties and counsel are saying. If you've got spotty audio, it just increases the frustration level and the difficulty level by a lot. The nice thing about Zoom is if you have a cell phone and you're not using the cell phone as your primary Zoom transaction point or connection point, then if you have Zoom and you've got the video and you have an audio problem, then you can always take your cell phone and dial into the Zoom session. And then the host can admit you into the session and put you in the same room where you are appearing through video. And so you appear twice, once by video, once by audio, but they sync up really well. And so that's very, very effective as a backup when there are audio problems. And you just let people know. So I always, when we start a Zoom mediation, I always give the parties my cell phone number, and I keep my cell phone with me close by, and I try and keep it free from any other interference or disturbances. And I don't put it on mute or, you know, silence it. And it's surprising how often I'll get a call on my cell phone as a mediation is progressing. And just this last week, we had somebody who was just dropping off, who just dropped off the Zoom, and of course you work through it. For parties who may not be on Zoom all the time, this would typically be clients or maybe others like an expert witness if they're going to participate. It's great to have them download and test the Zoom app in advance so that you make sure that the people that you're planning to bring, if it's family or friends or clients who are not technologically savvy, that they're comfortable using these technical things. The thing you don't want to do is discover these things on the day of the mediation. And if people are getting on for the first time or they're not terribly familiar with it, you can chew up valuable time at the start of mediation. Frankly, you know, a mediation starts at, you know, standard time, say 10 o'clock. And it looks like you have the whole day in front of you. There, as we all know, there are different grades of mediation. There are some that are very easy to resolve. Somewhere just with the slightest kind of whiff of air, they're going to resolve. Others, the parties are way far apart. If you have a mediation that's just poised to settle and they just need somebody to do it, then these issues are not so significant. I mean, you may not have a great need for all the available time. But if you have a really hard fought mediation, or we know this, that mediation is a process of change. And if people's perspectives are going to need to change in order for there to be an agreement that day, then what looks like at the front of the day, a lot of time can actually evaporate really quickly towards the end of the day. And if you spend 2 or 3 hours just marshaling the facts and making sure you have all the necessary facts down and together, and people are finally in agreement about them, and you understand the respective contentions and defenses and claims of the parties, and that can take several hours to really get that down. Then you move into phase 2, which is trying to actually get the settlement or starting to talk money. And that's a whole separate piece. It can take hours and hours. And so if you don't have enough time to put these things together, and people start to get tired, or they've got other things they want to do, or they're just exhausted, or they start to get frustrated, that day at the front end that looked like it had just all the time in the world can all of a sudden change. So that even at the start of the day, the time is precious. And so you really don't want to chew it up on something that could have been done in advance, like these technical items. It's valuable to make sure that you have a clear road to signing an agreement. So sometimes people might have access to DocuSign. I've seen that used a lot, or Adobe Sign. Sometimes parties just aren't very technologically well equipped at home. So at least if they have a printer, if you're not using DocuSign, they can print out a settlement agreement. And then if they don't have a scanner at home, which oftentimes they do not, they can take a picture with their cell phone and use that. And I've seen that used a lot. So either they have a printer at home or an e-sign alternative. some way to sign an agreement that day so that you don't have people going home and talking with their brother, or their sister, or their aunt, or their uncle, or their friend, and saying you did what, and then people rethinking this and then wanting to negotiate and back out. And that doesn't happen all the time, but it does happen sometime. So if you can sign something that day, then that's ideal. And when I first started mediating, 30 years ago, young attorney, I went to a mediation where I had a bit player, just a really small cross defendant. And so I didn't have any traction in that mediation. No one was interested in me. I was sort of a cast of thousands type of thing. And we mediated hard all day. We got to the end. And by the time we got to the end, it had been a long day. And the two primary counsel for the plaintiff and the prime defendant said, you know what, we've spent all day on this. It'll take way too long to put together a settlement agreement. We'll prepare something next week. We'll circulate it around everybody and we'll wrap it up right away. They said that. And it took a full year to get that settlement agreement negotiated and signed and put together. And it was so frustrating that when I did that, I thought, I'm going to try and avoid this if at all possible. And ever since then, I've been a big fan of signing the actual formal agreement on the day of the mediation whenever possible. Sometimes it's not possible because it's too complex, or you have to include a promissory note, a deed or trust. Sometimes you have to come back. And so you might be able to make accommodations and use a generalized descriptor, like we'll use standard terms in use in Northern California, whatever. But sometimes it's just too complex. But if it's not, I always try to get the formal settlement agreement done that day, just so you don't have somebody going home and having buyer's remorse and rethinking this, decide we want to reopen negotiations. And I've seen it done. And I've seen people who wanted to do it or tried to do it and could not, because the settlement agreement was signed. When I was litigating as attorney, I had some people that wanted to do that. And we'd signed the formal agreement and we just didn't have to revisit it. So I always try to do that. To that extent, I recognize that there's a cost to putting together a formal settlement agreement. There's time and it's a cost to clients, but I will regularly invite one or both counsel to bring a fully prepared settlement agreement to the mediation, so that if we get agreement, then we don't have to spend, at that point, spend another 2 hours or 3 hours preparing the agreement. We can start negotiating the agreement, and it helps with the flow. And frankly, if people get frustrated or tired, their tolerance level sometimes for mediation goes down. And sometimes you can see people saying, you know what, I've just had enough today, or they throw in the towel or get frustrated. So I try to always avoid that by making things as smooth as possible to try and maximize the chances for success. Stamina and morale is important. Talking about kind of perspective. We all know that mediation is emotional, or can be. A lot of times there's a lot of emotion, both by parties and by counsel. And counsel take their responsibilities seriously. And they identify and they adopt their client's perspective and their client's sense of having been wronged. See that continually. So the thing you don't want to have, if you can avoid it, is somebody getting over the top frustrated, or just I've just had it, and calling off the mediation on a case that could otherwise be settled. So in a non-COVID situation, when people are actually showing up, maybe after COVID's been resolved, but if people show up to mediation and you want to keep their morale up, I really appreciate this quote from Virginia Woolf. One cannot think well, love well, sleep well, if one has not dined well. When I first started mediating again, and the way it works is the younger attorneys a lot of times take their cues from the more seasoned attorneys who have done this a lot, and it's just the way it works, I think, in many, many instances. When I first started mediating as a younger attorney, sometimes I'd go to these mediations and the more senior counsel would say, you know, let's just push through lunch, and everyone would agree, and we would push through lunch and no one would take a lunch break. I think they wanted to see if we could wrap the case up quickly. If you can do that and you can wrap a case up by 12:30 or even by 1, fine. But you can't always see that far down the road. And so if you get to 1:30, 2 o'clock, 2:30, and people haven't eaten anything, if it's not an emotional case, fine. But if there's emotion involved, or frustration, or a sense of having been wronged, then the thing you don't want to do is put the case in a situation where someone just goes over the edge, just says, you know what, I've just had it, the other side's being intransigent, you know what, let's just go litigate, or we'll do this another day, or whatever. And so there's, I think, some real value when you have mediation, either to take a lunch break or to make sure that someone has made arrangements for something to be brought in. Hopefully that's going to leave people feeling good. So when I arrange for food to be brought into a mediation, I really try to avoid, greasy hamburgers and French fries and lots of ranch sauce or whatever, because, I can't speak for other people, but I know when I eat that stuff 2 or 3 hours down the road, it's not always a great feeling. So, I pay attention when I'm supplying the food to make sure it's going to be something that's somewhat fresh, and, try and take food preferences and those sorts of things. I mean, that's always a concern. If people have dietary restrictions for whatever reason and they can't eat what's brought in, then that doesn't do any good. So that's important, but it all makes a difference on morale, and morale sometimes makes a huge difference on perspective, and perspective sometimes makes a difference on if people are willing to continue. Get what you need. I suggest a roadmap to resolution. And this seems self-evident, but it's not always done in advance. So here's a for instance. If it's a breach of contract case, then it's so important to get the documents and the estimates or the bids that you'll need to calculate your damages. It's tempting to sometimes think, I'll just mediate and I'll see where the other side's at. I'll use this as kind of an exploratory tool, but maybe not work up my case. And you don't necessarily have to fully work up the case, but at least on the damages aspect. If you show up and the case isn't really worked up well, it's so hard to advise your client as to, how much should they accept or what are you willing to do? And then you're kind of hesitant to really do too much because you don't want to leave yourself short. If it's a breach of contract case and there's some damage that's going to be repaired, it's so worth it, I think, in virtually every case, to actually spend the time to go out and get the estimates or the bids that you need to repair the damage or to complete the contract, even though it's an extra step and a cost. Then you know what you're dealing with. Then you're in a position when you get to mediation to really fully evaluate the other side's offer and whether or not you can live with it and it's going to make sense for your client, what's going on. If it's a specific performance case, like a purchase of a business, it's just essential to identify all the licenses that you'll need in order to fully operate the business and how you're going to get them and what kind of cooperation you might need from the other side. Because if you go to mediation and lo and behold, even though the other side's been intransigent, now all of a sudden, through whatever, they're willing to do a resolution, and you're going to commit this to a settlement agreement. You don't want to leave out some essential term that you need in order for your client to get to where they have to be on specific performance because they didn't identify it, especially if it requires cooperation from the other side. So in advance of the mediation, I call this the roadmap to resolution. If you stop and you think about, if we can get to agreement, what do we have to have in order for this business, for title to the assets and the licensing to be fully transferred so it can be operational? And there's a lot of different businesses that require some licensing and possibly some cooperation from the other side. If it's a construction cessation case, an abandonment case, calculate the delay claims, get the bids to finish the job. If it's a construction defect case, identify the full scope of the defects and get the repair bids so that you're fully prepared when you go in, you can see if you can get to resolution. If it's a probate, a trust litigation, or another family-based case, look for and identify any non-monetary values that may hamper settlement. I have an older friend who is really a wit. It's just a real wit. And I was speaking with him just this last week, and he made me laugh. He got this a little bit different, but what he said was, he said, just remember, money isn't everything. He said, it's the only thing. And that made me laugh. In many cases, that's going to be true. The dispute really is about the money. But in some cases, it's not true. In some cases, it's not true. And so you really have to evaluate the case. Is this case about the money or not? So sometimes the case really is about the money. So a good example is maybe a soft tissue, low impact auto accident, and there's some meds and a lien and some pain and suffering. And maybe the issue really is primarily or solely about the money. But oftentimes, what's really at stake is what the money represents. So money can represent power, control, morality, ethics, a sense of rightness, a sense of fairness, a ledger book mentality, a way of keeping score. And there are clues, there are signals that the parties give, both to their attorneys and to the mediators, that let you know that you're talking about something like this. So here are some examples. They need to learn a lesson. I can't let them get away with that. I can't just stand by and participate in this. I'm not going to stand by and let this happen. I don't care how much I get. I just don't want them to get more. Dad or mom would not have wanted it this way. And then this is the capstone one. It's the principle of the thing. Anytime we start getting these kind of comments, that's a really significant signal that there are other values here at play besides just money, and that the money may well represent what's really going on or what's important to that party. And I've seen this happen, you know, somebody's making a demand and then they get asked the question, is this about the money or about what the money represents? And having them say, oh, it's what the money represents. They recognize it. It's not that I want or need the money. I just don't want them to get more, or I don't want it to go down this way. Super important. So this can happen especially in family contexts, like with the probate and trust cases, but it doesn't have to be just even a case where the parties have a pre-existing relationship. So some years ago, I was at a training presentation, and afterwards, a mediation training presentation. Afterwards, I was speaking with one of the other attorneys there, and they told me about this case that they'd had, where it was a wrongful death case of a young person. And this attorney took this case, took it all the way to decision, got a really great result, really great award, and went and presented it to their client, the parent, and said, here's what I got. Isn't that great? And they were floored because the parent didn't seem particularly pleased with the result. And the attorney said, is something wrong? And the parent said, you never asked me what I wanted. And the attorney said, well, what do you want? And the parent said, I want a park bench that's got my son's name engraved on it, that put up in memorial of my son. And the attorney said, well, you just got a huge award. You can take just a tiny bit of that money and put something like that together. And the parent said, yeah, but I want them to pay for it. That kind of comment shows a huge value by that parent. And it isn't just money. It isn't apologizing with a pocketbook. It's an acknowledgement of a wrong that's done and a life that's lost and the value of that life. They wanted acknowledgement. I mean, for them to say, you never asked me what I wanted, means that they're taking all their instruction and counsel and advice and really great advocacy by their attorney and going with it because that's the way things have to go. But there's this unstated value that's inside. And so when we have our clients, whether we're acting as counsel or when there's clients involved in a mediation, if we understand the values of that client, then we're in a far better position to see if we can match those values. And if we can meet those values or acquire what's important for that person so that value is satisfied at very little or no cost to the other side, so that it's not a zero-sum game, then that's a great way to in a very creative way, see if you can get to agreement. But you have to get to those values first. And people don't always come down and just lay them down in a mediation, either to their attorney, as in the example I just gave, or to the mediator. So in a mediation, in a very real sense, the mediator comes to this with the briefs, which the attorneys, or if it's a pro per, have put a lot of time and attention and effort into to really bring the mediator up to speed on the salient facts, the applicable law. So the mediator comes in with that benefit. But once that's all done, that's all two-dimensional. It's black and white on a page. Once that's done and the mediator is actually involved in the mediation session, it's just this enormous influx of information that's all done in real time with very little time for reflection or evaluation or further preparation. It's all done in real time. Sometimes that's additional law. A lot of times that's additional facts. And then it's all of the emotion and all of the personality of the parties. If you think about it, at the end of the day, everybody that's necessary, and there's an exception with insurance. I understand insurance cases, you've got the adjuster there. Sometimes the decision maker is on the other end of the continent and it's a different time zone. This person may have limited settlement authority. So I'm putting that aside where you've got an off-site decision maker. They have limited authority for that day. Other than those situations, in the majority of mediations, you have all of the necessary parties present who are going to be necessary to make a decision. They're all right there. And either they're on different screens in Zoom or they're in different rooms in the same location, but everybody's right there. And at the end of the day, and I think some people will take exception with me on this, but it's true. At the end of the day, what's going to happen is what's going on with people's hearts and with people's minds. And if their minds and hearts are in a situation where they're prepared to do a deal, it's going to happen. The rest of it will follow. Many times, I grant you, that is driven by money, and it's driven by amount of money or timing or payment, sometimes by some of these other principles. But I think the importance and the value of where people's values are and understanding that, where their hearts are at, and where their minds are at in the appropriate case, just can't be overstated. And it's true. There's a lot of cases where it's just going to be the money, and maybe hearts and minds are not focused so much on non-monetary considerations as they are the money and the potential risk of going forward and the cost and the time investment, all those sorts of things. But you've got the hearts and minds all present in those rooms. And if you can get those to a point where there's an overlap, you've got a settlement. Get the other side what they need. Assess the other side. Did they understand the law? You know, sometimes in a mediation, both sides understand the law perfectly and it's a non-issue. But if you're dealing with an attorney who doesn't practice in the area of law that you're dealing with, they may not have a really good understanding of the law, and they may be getting hung up on some things they shouldn't be because the law just doesn't work that way. So as the attorney, you have to make an assessment of the attorney on the other side. How often do they practice in this area of the law? Do they understand the salient legal points? If not, you may need to actually bring them along so that you can get to the point where they understand the law, so they can understand the strength of your position or the problems in their own client's case. They may not fully understand it. So you may have to educate them. And we all see this as attorneys. I mean, very often as attorneys, we have to do the other side's job sometimes so that we can get what we need, either as an attorney or in other situations, or sometimes we have to do stuff for our clients that they should be doing, but they haven't get it done. And in order to move forward, we have to do that. So we understand that. It's absolutely present in mediation. If you have an attorney that doesn't understand the law and you kind of get that sense, then you have to make a decision. Is it worth my client's time, money, and my time to put together a brief that's really going to outline this stuff in a real clear, understandable fashion? The benefit of that, of course, is that it goes to the mediator as well. And then the mediator is you're sure they're fully briefed and there's no issue about maybe the mediator not understanding a fine point. Does the other side understand the facts? I mean, we all know that this happens. Your client comes in and talks with you and you get one side of the story. A lot of times it's the full side. You don't have some missing fact or even a spin on it. But also, a lot of times, the client doesn't fully understand the other side's perspective. They may not have understood the full facts. They just may not understand exactly what's going on. And plus, if they've been wronged, they're dealing with that wounding or that hurt, and it sometimes can shape their view of things. So as the attorney you come in, does the other side understand the facts that show either that they have a problem with their case or that you have a really strong position with your case? And again, if you think they don't understand the facts, make sure you lay them out so that they're clear. And then obviously, again, it really helps the mediator to understand this when they come in. I mean, one of the big benefits about a really thorough brief, and sometimes, you know, I have situations where people don't want to send me exhibits to key documents. And I always ask for the exhibits. And I try not to overdo it to spend more time than is necessary in them. But sometimes the exhibits have really powerful information in them. And if that might be a motion paper that they file, they send, or other situations where there might be exhibits that are key documents that they want to put aside. So I ask for the actual contracts. If it's photos, I ask for the photo. If it's a physical kind of situation case like a trip and fall or some other thing with a photo. If I understand the facts and I can present them as a mediator, then I can help that process sometimes if one side's struggling or doesn't have a full understanding of the facts. And we spend so much time in mediation making sure we understand the facts. If I have this all in the brief, then I always encourage parties to exchange briefs. I always do that. And sometimes people have different perspectives on this and they don't want to do it. And I'm saying, if you've got something for me confidentially, send me a separate brief. But the time at mediation is precious. And if the other side can understand your perspective on the facts, then we don't have to spend the first hour or two of mediation getting the other side up to speed on your facts from your perspective. That's already done by the briefs. Then we can go to work on the other things where there are disputes or disparities, or working on the numbers. And so I always encourage people to do the facts so that that's all done, and it can make our time so much more efficient. And if you don't want to, if you've got trial by ambush, I mean, that's quote unquote, that's disfavored. But if you've got the fact that's going to make a difference and it can't be discussed now, and you've got to save it for trial and present it at trial, and if you can get through discovery without being asked for it, fine, take that up separately. I've seen that with statute of limitations defenses. The other side just didn't realize there's a really powerful statute of limitation that was about to expire. It hadn't expired yet. Maybe one side doesn't want to say, well, by the way, you're going to blow your statute in 3 weeks, but mediation is today. If you're going to do that, put that in the mediator separately, or maybe you're not even going to talk about it at all, but give everything you possibly can to the other side so that they understand where you're at and we can make our time efficient, maximizes the chance for settlement. What are the other side's values? Now, there's kind of two schools of thought on this, or at least two applications. I think as attorneys, when we come into mediation, clearly we're primarily focused, as we should be, on our case. What's happened with our client? What are our claims? What are our defenses? What is our case? And then what we end up doing, if we're being effective, is we're supplying our best facts and our best law to the mediator so that they can explore those with the other side. So we're equipping the mediator when we give them a really good brief to go talk about that. What about this? They go on the other side, what about this? And then you flesh it out, and where is it? There really isn't much to be accomplished, in my opinion, about hiding things at mediation. And when I say hiding things, if there's a key fact, like I talked about, a defense that shouldn't be brought up now for whatever reason, fine. But on other things, if the other side doesn't understand where I'm coming from, and I think I've got some really great perspective or a great fact or a great witness, and they don't know about it, then how can they possibly evaluate that in conjunction with their mediation proposals? If I think I've got a strong enough case that I don't have to have that fact or witness, fine, then maybe I don't talk about that at the mediation. But most of the time, that, in my experience, that's not the case. Everybody needs every piece of fact and every piece of law at their fingertips, or that's available to them, to try and persuade the other side. So you get this to the mediator, they go in and work with the other side, they try and persuade the other side, and then they come back and talk with you, fine. In any mediation, there's going to be values on both sides. And if the case is going to be settled, the values of the other side have to be met to the point where they're willing to come to consensus. So I think it goes without saying, isn't there a significant value if you understand the other side's values? Doesn't mean you're going to agree with them, doesn't mean you're going to meet them, but at least if you know what they are, then you're prepared to address them and decide whether or not you're going to meet them or not. Now, if you've got a case where it's an auto accident and there's an insurance company on the other side and they're perfect strangers, you may not have as much of this kind of valuation consideration available to you, or it may not be as important as a probate and a trust case where people have a whole lifetime of experience with each other. And there may be very significant non-monetary values on the other side. Or the case I talked about, like with the park bench. Sometimes those values can be present. If you understand what they are, you can see if you can creatively meet them without breaking the bank. This is the values that I've talked about just now, about understanding or at least making an assessment, trying to probe and get a sense of what the other side's values are, has really been for counsel. There can also be this kind of a question to the parties in a mediation. And it's not appropriate for every case, but in some cases it absolutely is. What do you think the other side wants or needs in order to settle this case? If the other side is an insurance company, this is not an issue. But if there's a pre-existing relationship, a business partnership, a joint tenancy, a tenancy in common, a probate or trust case where there's family issues or disputes over an asset where there's common interest in the asset, family heirlooms, things of sentimental value, commonly owned property, partition actions. What do you think the other side wants or needs in order to settle this case? There's two benefits to this. One is if you have parties that have a long history or any kind of history with each other, there may be information as a mediator that one side might have that is helpful for you to kind of understand the needs and the values of the other side that may not have been talked about in the briefs or otherwise. This question brings it right to the head. So basically, as a mediator, you're saying to the one party, what do you think the other side wants or needs in order to settle this case, as an exploratory tool to help you understand the other side that they may not be telling you. Okay, not that they're necessarily hiding it or holding it back, they just haven't identified it. That's one value. The second value is something like this. And again, these questions, as with most questions, have to be used with skill and judgment and care in appropriate circumstances. It's absolutely not one size fits all. But a question like this, if used skillfully and appropriately, can sometimes help a party kind of get out of their own wound or their own being so heavily focused on just what they need, and can kind of just open up a little bit, open their eyes a little bit, or open their perspective to the other side. If this is used at the right circumstance, at the right time, and this is after someone's been heard and they know that you understand their case and that you appreciate the wrongs that have been done to them, if they see this on the other side, and if this question is asked, and if they're willing to entertain it, then the focus shifts from being completely on their side of the case and starts to look at what the other side needs in order to settle this case. There are some powerful things that can come from that, because now what happens is you kind of collectively work as a group, saying, what does the other side need in order to get you what you need? And so then you're working at this thing in a holistic environment, instead of just trying to beat the other side into submission or intimidate them or threaten them or bludgeon them or whatever. It can really be very effective at the right point in the appropriate case. If the other side doesn't understand the law, educate them. I talked about this a little bit a minute ago. In a mediation brief, I mean, your mediator is going to read your brief. If there are propositions that are what I'll call hornbook law, that may not have a whole lot of value. You don't need to have long string cites. That's really not the point of it. And the mediator probably, if they're familiar with this area of the law, won't read a whole lot of string cites. If there's a salient point or salient case, then talk about that one. And it can just be mentioned in passing in case the mediator may not be familiar with that particular point. They can look it up, which can be very helpful for the mediator. But especially if there's a key legal point, then it can be very helpful to have a case or a statute cited there. Because everybody knows this, the law is so broad and it's so complex that it's hard for anybody to be up on every piece of it. And so if you get a point of law that you may not be familiar with as a mediator, then you can just look it up and make sure you understand it. And so I don't always do it, but a lot of times if there's a key case that's cited in a brief on something I'm not familiar with, I'll read as much of the case as I need to be sure I understand the case. And that can be very helpful, can be very powerful when you understand that case law as it applies to this case. That also gives the opposing counsel to do it if they're not up to speed on it. So if there is a key point of law, I think it's worthwhile to do what I call a signal, to signal to the reader, whether that's the mediator or the other side, that this is a key point. And you can use whatever words are appropriate, but to not just put it in there as kind of a rote citation to establish law, say, this case is really on point, or this case is, highlights this, or it has a lot of value in this particular case. Those kinds of signals to say, hey, this is an important case or statute. You might want to take a look at this. And I do. I pull out the statute book, I pull out the case law, I read as much of it as I need to. And so not all of the time, a lot of the cases, I'm familiar enough with the law, I don't have to do that. And it wouldn't be a good use of mediator time and the party's resources for me to spend that kind of prep. But if it's not something I'm in all the time or a key point, it can be very helpful, very powerful. There's different schools of thought on this about including key documents. You know, some mediators may not want to see the actual documents. They just want to understand the issue and then get right sort of down to the nubs. I like to see the actual key documents, whether it's the contract or if it's an email, you know, and I have a couple of thoughts on that. You know, certainly a key point at trial and a key point at mediation is persuasion. At trial, the persuasive effort is directed all to a third-party neutral, judge, jury, arbitrator. At mediation, the persuasive effect is directed a couple different directions. It's directed to the mediator, opposing counsel's client. So you're trying to persuade everybody on that about the validity, the strength, the value of your position, whether it's a claim or it's a defense. If I get a mediation brief and it just says, so-and-so sent this person an email and they said yada, yada, and it just, whatever it is, okay, that's helpful for me to understand the overall perspective. But if either the text of that email, and that's the great thing about this word processing technology we have these days, it's really easy to just take a photograph or some key language and just drop it right into a brief, just right here, so that you've got the flow of the brief and then you've got this key point and you've got the flow of the, I have seen that used to what I consider to be great effect. It just gets dropped right in, not to excess, but the key points is just dropped right in. And then I think what's even more powerful is, and then you attach the full document as an exhibit at A or B, or exhibit 1 or 2. Then there's no question that it's not taken out of context. You can see the whole thing. You get the picture of how it all flows together. And if I see an email that's summarized, but as instead I see the actual language of the email or the entire email, we all know that oral contracts are as binding as written contracts. The legal effect is exactly the same. They're both binding. The only issue is in the proof or in the evidence. The reality is, if you have a statement, an allegation of an oral contract, well, if that's believed, then the trier of fact can find, yeah, this happened, and then the rule is that it's binding. But on the other hand, if you open up and you've got the actual written contract that's there, you can actually see the words and see the signature at the end, even though the legal effect is no more strong than with an oral contract. Just the fact of having that written there seems to give a sort of resonance to it, a sort of additional weight to it. And you see some repercussions of this in the law of evidence, you know, self-verifying detail, that kind of stuff. So if I have a summary of an email, or instead I have the actual email, even though I'm only functioning as a mediator, not an arbitrator in that context, it just has an added resonance, an added weight, and added strength. And I think without question, there's a value to counsel as they come into mediation. If you put your case up to the mediator, the first person you're really trying, you have to convince the other side and the opposing counsel, but the first person you're really trying to convince or persuade about the validity and the value and the strength of your case is a mediator. And so if the mediator reads this whole brief, I mean, mediators are people too. We absolutely are. And if a mediator comes out and thinks, oh my gosh, this is a really serious claim, or this is a really serious defense, even though they are going to be neutral and they're not going to go in and play favorites with either side, at the same time, if they have that sense as they go in to talk with the other side, it just puts it moves the ball that much further down the field on persuading your mediator and having them explore in a very real way with the other side. Well, how are you going to deal with this at trial? Or how is this going to come across? Or what do you think? It surprised me. It surprised me when I became a mediator to find this happening, but it does. It surprised me to find that sometimes in a mediation setting that counsel will say, what do you think? And they'll be asking for a true kind of a second set of eyes or second opinion. And sometimes that happens. And, you know, when I'm a mediator, and approaches can vary on this, I never try to weight that. I don't try to weight it in front of one side or the other. But if asked, that's moving from facilitative to evaluative. I'll give my opinion. And sometimes people, you can just see counsel are thinking about that. They're turning it over. They recognize that here's someone that's highly experienced in a certain area of law, and it's another set of eyes, and they maybe haven't taken it to their partner or to another attorney and done that. And sometimes they'll use that in their own evaluation. You can just see it. You can feel it. Well, if you've put in the actual documents so they have an additional weight or resonance to your case, then when your mediator talks with the other side, if the mediator has that sense about them, it just helps the mediator get a more full evaluation of that case as they're talking about the other side with that. Does that mean that that somehow improperly weights a mediator to one side or the other? I don't think so. I don't believe that. As a mediator, what I'm interested in doing when I get into these mediations is I want to fully understand somebody's case. I want to understand the defenses. I want to understand the claims. And again, I'm putting aside any fact that maybe is confidential, is not going to be discussed because it's trial by ambush or whatever. Fine, leave that off to the side. But except for that, I want to really fully understand the case, because if it's a low-hanging fruit case and there's not very much effort that has to go in, then none of this makes any difference. I mean, the case is going to settle anyway. It doesn't make a whole lot of difference what you do. Okay, but if it's a difficult case and parties really are far apart, and you go through this process of change over several hours, then I believe this: the parties are best served if they really understand each other's case. Because otherwise, if they don't, then people are hanging back thinking, well, I'm only going to give this much, and I'm going to hang back on this stuff. We'll see what they do with it, and I'm not going to disclose this stuff, but I want to see where they're at. Well, if that's one of those confidential things, then yes, you have to do that. Or if you can get the other side to where you need them to be as one side without kind of going through all that, then that's fine too. But that's not my experience. My experience is that most of these mediations, it's very hard fought to get to the point where the parties are at an overlap where there can be a settlement. And so if the parties really understand each other's cases, so that as a mediator, I can fully flesh those out with the sides and explore their cases, then we maximize our chance of having a settlement, because the other side understands the strength of the other side's case or the weaknesses of their own side. And most cases are going to have that. Most cases are going to have some stronger points and some weaker points. Once we understand those, then we can talk about those in mediation. I've also had situations with key documents as exhibits to mediation brief where, and this is, it's an unfortunate reality of litigation. The reality is that law is complex, and it just is. The facts are complex, the law is complex. It's a highly complex line of work and profession. And it is easy. There is so much complexity. It's easy to miss a point of law or to miss a fact. It's easy to do that. And so I've had cases where maybe both sides come in and neither side has identified an absolute defense that one side has. Neither side has. Okay, and you get this documentation as a mediator, and you look at this and you're going, holy smokes, there's a complete defense. So for example, an unreleased contingency in a contract. Hey, never been released. And one side claims breach of contract. Well, wait a minute. We have an unreleased contingency. How is it possible that counsel would not identify an unreleased contingency? Because law is complex. Law is complex. It's easy to miss that. I've seen that more than once. And so what happens is, as a mediator, our mantra really, as I take it on mediators, is to do no harm. Sort of like the medical profession, the Hippocratic Oath, do no harm. So if the parties come to me as a mediator and the case does not settle, I can't in good conscience prejudice either side if they go forward and they decide to litigate. So if things come to me and there's a complete defense, the last thing that I'm going to do, and I'm not going to do it, I'm not going to go to the side in whose benefit it is and say, hey, by the way, did you notice you got a complete defense here? Because that would prejudice the other side, and that's not my job. It's not what I'm tasked to do. It's not what the parties trust me to do, and it won't help get the case settled. It's just wrong. I'm not going to do that. But you can bank on the fact that if the parties come and there's a complete defense or something like that, that I'm going to be talking at length with the party who's going to lose because of this complete defense, and say, have you looked at this? You really better try and do something about this right now, and see if we can get to a settlement. And so sometimes I've had cases where people come out of the mediation going, wow, that went a lot better than expected. Well, sometimes some of these things come up, and there you have it. So if I have the actual documents, I can do that. That's not the primary purpose of mediation. That's kind of a little bit of a side point as far as having the actual documents or exhibits. The primary point for me is that that they give a sense of resonance, and it helps me better understand the feeling of the case. And I have that with me as I go in to talk with the other side about that side of the case. Sometimes there can be talk about doing a free mini deposition, and sometimes counsel say, I'm not going to give the other side a free deposition. Well, I understand that, and there may be reasons why that makes sense and why you don't want to do that. My suggestion is every case is unique if we choose to view it that way, and there can be cases where a free deposition might be a good idea. If you don't have confidence in your client and they need a lot of preparation, or you don't know what they're going to say, then the last thing you're going to want to do is give the other side a shot at your client or at your expert witness. But I've had more than one case where the parties come together at the mediation, for example, a construction case, and they came together at the mediation, and it was clear that one side didn't have their arms around what the other side's expert was going to say, and it was an expert heavy case. It was just clear. And so so I said to the one side, hey, can you get your expert here? They said, well, I don't know. Well, call him. I called him and said, yeah, he's around today. I said, well, bring him out. And so then the other side, is going, well, and so it's like, we need to pause this mediation. The expert's going to, well, we want our expert. Well, are they available? I don't know. Call them. The other side. And so get both experts out there at the mediation. But nobody had made any pre-arrangements for those experts either to be present or even to be available that day. But it became critical. And literally, you can have a situation where the experts can cross-examine each other. That doesn't happen unless you're really confident in your expert. But it can be absolute dynamite if one side does not fully understand, and it can be both sides, what the other side's experts are going to say. It can just be dynamite and super effective. We resolved that case, but it would not have happened without doing that. Or I've seen cases where maybe one side will agree to offer up their client, right in the mediation, go ahead, ask them whatever you want. I won't even ask direct. Go ahead, ask direct. No objections, just lay right down. There are so many clients where that would be just a broken down picket fence, bad idea. Okay, it's just not a good idea. But in the right case, if you have the right client and the right facts, and you have absolute confidence in your client, you're not going to have the time to prepare them or walk them through it. You might sit down and have them do that. And of course, everything's protected by mediation confidentiality, so you have a chance to work on the back end. But if they say the wrong thing, it's just going to make the other side feel completely violated if you're just completely changing everything. So it's the appropriate case. It's probably not even close to the majority of cases, but in the right case, it can be absolute dynamite if it's appropriate and if counsel are willing to do it. So everyone has to make that evaluation on your case. Am I willing to do this? Am I not? How much difference would this make for settlement? If the one side does not understand the other side's perspective or their values or how they're going to present at trial, sometimes you get in these mediations and one side you can tell they're just going to make really stellar witnesses. The other side hasn't talked with them. The other attorney hasn't talked to them. They don't know how it's going to present. You're just going, well, is this something we want to do? First, you have to ask the client, would you be willing to do this in a joint session? Let the other side ask some questions or client, or you ask them direct and let them follow up direct, or even just you ask them all direct and no cross. And if they're not, then you don't go there. But if they're willing to do it, and if the other side's willing to do it, like I say, depending on the case, can be very effective. These are all the things that we've just talked about. A lot of times our clients have been wronged, and we carry the torch. We carry the sword and the shield as attorneys, and it's like we're leading the charge. And it's not always our first stop to think about what does the other side need from me in order to understand the strength of my case. It's like I need to sort of beat them down because they're being so unreasonable. I'm going to have to put this in front of a judge if they don't come around. But if we evaluate the other side We've talked about this. What do they need? So I'm going to suggest too that to the extent possible, it's a great idea to avoid fatalism. And here's an example. Either the case will settle or it won't. Doesn't make a whole lot of difference what I do. The attorney or client on the other side is completely intransigent. Maybe the mediator can get them off the dime, but probably not. The other side's so unreasonable, it's not worth the money preparing any kind of significant brief because they won't budge anyway. I mean, when I see this happen, when I see the one side just completely convinced that the other side is never going to do anything, sometimes they're right, but sometimes they're not. And the thing is, you don't know what's going on in the other room. And so maybe one very consistent hard-nosed approach has been telegraphed to you during the entire period of litigation or pre-litigation negotiations, but it's possible that a different message might be communicated or being communicated to the mediator. You don't know. And so what we do know is this, that in negotiation and in litigation, it's just legendary for one side to not telegraph to the other side their true position. It just goes without saying, because the plaintiff is concerned that if I telegraph my true position or my true numbers to the other side, they're going to chisel me down. And on the defense side, it's like if I telegraph my true position or whatever, the other side, they'll work me up. So it cannot be done. But that's part of the genius of mediation, is because you have a mediator without a dog in the fight or without a stake in the outcome. Then a lot of times counsel will share more with the mediator than what they're willing to share directly with other counsel. So, you know, if you have highly experienced counsel, very, you know, lots of experience, very capable, very competent, real hardworking, smart, just really ready to go to town, and they're getting all the signals from the other side, it's very easy to think, you know what, I'm going to lead the charge. These guys are being intransigent. I'm going to just chop at this thing and take care of it. And sometimes it's tempting in those situations to disregard what the mediator says, because it feels like you already know where the other side's at. So at that point, it's a question of how much trust do I repose in the mediator's perceptiveness of where the other side's at? I mean, if the mediator is saying, maybe we ought to try and do this or that, or have you thought about this? It might be because of the messages they're getting from the other side. That might be very different from what you've gotten so far. That does happen. When you write your brief, it's valuable, I think, to remember who you're dealing with and the purpose of the mediation. We've talked about this. It's often, in the difficult cases, a process of changing people's hearts and minds. Now, as counsel, we adopt many times our clients' perspectives and truth. Many times our clients have been wronged by the other side, who, by the way, are sitting in the other room. They've been wronged, and it's not been well done. And there is a real tendency in our line of work as litigators to be a champion, or want to be the champion, and to be the advocate and the champion of our client's cause. And so you just really want to sort of lead the charge and say, you know, this person on the other side is all bad or all whatever. And sometimes it's tempting to put that in the briefs. And so if the other side looks like they've been completely intransigent, it's easy to kind of start what I do, maybe name calling or insult in the briefs. Here's the problem with that. If there's going to be if this is a trial and you're putting this up to the judge, you still have to evaluate how effective is it for some third party neutral that has no stake in this and has not been wounded. If I'm laying all these claims or charges or labels at the other side and they don't know who's right and who's wrong, or who the good people are or the less good people, they don't know that. So you have to evaluate that even at trial, but certainly in mediation, you just know that in many instances, probably most, counsel are going to share briefs with their client. And if the client has adopted if the attorney has adopted their client's perspective and are carrying the charge, then if the client's motives or counsel's motives, even more, are impugned, then experience shows that the natural reaction is for people to get their backs up and for emotion to just spin up. And certainly the client on the other side sees this, and that just spins them up. And so what happens is before the mediation can come to resolution and settlement, that spin up has to be brought back down. And you have to talk through this, which takes time and emotional capital to get there. In other words, insult or insinuation, most of the time, maybe all the time, is not going to move the ball down the field towards resolution. Instead, it's going to be a detour. It's going to take time, emotional capital, and may actually do some wounding that may even make it more difficult to get to resolution. So in the mediation brief, my suggestion and invitation is to very carefully weigh not only the labels and the terms that are used, but the whole tone of it, and whether it's an attacking tone on their motives or something else. Recognizing the purpose of the mediation brief is not to lead the charge or to write the universe, basically. It's to try and get to consensus with the other side, if that's what your client is attempting to do. Again, sometimes there's different motives, different values. Maybe my value in litigation is to punish the other side, to beat them into submission, to cause the financial wound that actually comes with consistent attorney's fees bills and going through 3 years of litigation. And I'd actually rejoice in doing that myself because it gives me a charge. So maybe I'd really like to do that, but you have to really evaluate that. Overstatements, broad brush claims, and ultimate facts are rarely persuasive, but concrete evidence of specific wrongdoing can be like gold. So in a mediation briefing, I'm gonna go out on a limb and suggest this is true also in the law and motion practice. That rather than making a broad brush claim or an ultimate fact claim of this person is this, or clearly it's that, and they're like this, that because you're presenting this to an impartial neutral who's not shared the same wounds that your client has and hasn't got the same investment of leading the charge like the counsel has, that the more persuasive approach is to bring in specific evidence of wrongdoing in somewhat of a very neutral tone, or if not neutral, just slightly over the threshold of neutral, so that then the decider of fact can make their own evaluation and their own conclusion about who's right and who's wrong and who's been doing the wrongdoing and who's been the victim. And we've talked about this. Number 4, get the mediator what they need. So we've talked about this. Include the key documents as exhibits. Actual documents as opposed to summary. And if you've got a huge amount of documents, of course, it's going to be a summary. Of course. I mean, the mediator, you don't want to have the mediator getting bogged down in voluminous pages of whatever. So, of course, it'll be a summary. We've talked about this. Powerful mediators explore the strengths of your case with the other side. I mean, I remember when I first started mediation practice and the mediator would be gone for hours. You just kind of be scratching your head and looking at the wall going, what in the world is going on the other side? Well, powerful mediator is going to take your case and explore it with the other side. How's this going to present at trial? What's it going to look like? Are you sure you want to be there? Is it worth the risk and the cost to you? All those kinds of issues are being explored at length with the other side because that's the nature of mediation. Perspectives on this vary. When I do mediations, I always ask for the briefs, if I can, at least 10 days before the mediation, which is a long time, sometimes maybe more, but I try to get at least 10 days. And then I try to read them as soon as they come in. I literally try to read them the day they come in. And there's a reason why I do this. If I wait until the day of the mediation or the day before, I don't have any time to reflect on it. But even more so, I don't have any time, there's no runway to do anything on this. And so what happens is, if the briefs come in early, they provide for a thoughtful and an analytical mediator review. Sometimes, and this has just happened recently with me, there's an opportunity to invite additional parties, as we talked about earlier in this program, that may help fund a settlement because they may be interested in getting a release to buy peace as well. And it benefits that third party because if their contribution is material to a resolution, which that happens pretty regularly actually, then they're actually benefited because if the case didn't settle, then when the litigation gets filed, if it's going to be in Superior Court, they're named defendant. And so now they're defending a lawsuit that they could avoid if they took care of all this in a mediation. So I have a very expansive view, a positive view about bringing third parties or inviting them to the mediation. There's a benefit to them. They don't have to go on record as being a defendant in a case. They don't have to put their E&O carrier on record or on notice. They don't have to deal with all the angst of, a lawsuit and being served. I mean, they can resolve it at mediation. And if it's not worth it to them, then they won't settle. And then they can go through the litigation process if they prefer that. And sometimes they do, but not often. If I get the briefs and I read them early and there's something I don't understand in the briefs or an issue, then I get an opportunity to request key documents, photos, witnesses, or analysis. So this happens. I mean, sometimes counsel law is complex, so a good example, for instance, is the homestead exemption. They may think that if they got a plaintiff's case, then there's equity in the defendant's house that they come after them, and they may not realize that the homestead exemption just materially went up about 3 months ago. That now it's between minimum of $300,000, and then it's a maximum of $6 million, depending on the median countywide price in the year before. So if I get these things, these briefs, and there's a piece that's missing in it, either that I don't understand or that it looks like counsel may not have put in, it gives me some time to go back to counsel and say, do you have this? Can you supply me with that? This piece of information, this fact, this piece of law, can you check on this with somebody? And they're not scrambling around trying to do it the day of the mediation, but then they can fully understand the nature of this case. This happens with me regularly. It happens regularly, so that when we get to the day of the mediation, we have this teed up the most it can realistically possibly be teed up for a resolution that day. And we're not defeated at a settlement because of some piece of preparation that could have been done that wasn't, just because it wasn't identified or requested. Work effectively with the mediator. 2 key points. Listen closely to the mediator. We've talked about this. The mediator may be getting a different message than what you might be getting through the course of litigation. And also, frankly, the mediator can help you with your own client. Now that's not going to be in every case. In some cases, counsel, we have really good relations with our client, really good client control. In other cases, not so much. So here's the first point. Listen closely to the mediator. They may have information for you about how the other side is viewing their own case, and we've talked about this. Mediator have information about how the other side is viewing your case, okay? So maybe the other side just really denigrates one aspect of your case. If the mediator comes in and they're talking with you about, well, what about these issues in your case? And they may be hitting some of the weak points or the soft underbelly. Sometimes the natural instinct can be, well, and then go to work and sort of trying to beat that down and beat it back. But if you listen carefully, where you're probably getting these, it might be from the mediator directly. And if so, then that's something worth exploring. Or the other side might be asking those questions. So the mediator is really exploring this with you. So at least if you understand what the other side is viewing your case, you can maybe get a sense on where their values are. And if you understand their values or their perspective, that's additional knowledge for you as you decide what you're going to do. And knowledge is power. Yeah, we've talked about this. And again, these questions are, it completely depends on the circumstance, on whether you would ever ask a mediator this kind of thing. What seems to be important to the other side, okay? You don't want to communicate weakness to your own side. And so sometimes I think the tendency is to not ask about the other side because it seems like we're actually going to validate what they're doing, and they're so outrageous that it's just impossible, So if you're going to ask a mediator this question, you don't have to do it in a context of validating the other side, saying, you know what, we think the other side is being completely unreasonable and they're not taking into account our case and our facts and the realities and what's likely to happen at trial. But having said that, we're here to settle today. What do you think is important to them? Why are they here? Why are we not seeing any movement on their side? That completely invites the mediator to respond to you without honoring the other side's perspective at all. And it says, what's going on with the other side? That can be valuable to you. That can be important to you to understand what the other side has to say, because there has to be this overlap. And again, as you understand what's important, as whatever the mediator feels like is appropriate to share or to say, that can be helpful to you. Is there anything the other side's looking for that isn't monetary? Again, we think they're being completely unreasonable, all the same things I said, but I mean, is there something other than, we don't understand why they're not coming around to this kind of money we're talking about. So is there something other than money they're looking for that we haven't been talking about? So if there is something that's not monetary, I mean, that may precipitate an exploration with the other side, or it might help you understand if the mediator already knows about it, that might be something that's important to them, a non-monetary consideration. And sometimes those things are surprisingly important. Is this claim about what the money, or is it about what the money represents? Again, in the nature, just to understand the other side's values so you can see if you can meet them to get to a settlement. What's the emotional tone in the other room? Again, you may not ever ask this to a mediator, but if you have an interest in it, you can say, we don't understand why the other side's not responding. Are they just angry over there? Are they just being stubborn? Are they just refusing to see this? Do they want to try and exact a pound of flesh from us? Are they calm over there? What's going on? Because we don't understand why they're not doing thus and such. So you can phrase that in a way that's very positive to you, but still invite the mediator, if they think it's appropriate, to share with you some sense of what's going on in the other room so you understand and can take that into account accordingly. Again, depending on the case. The mediator can help you with your own client. Sometimes if we have a client, real frankly, when I come into the room as a mediator, there's really 4 key variables that are going on. And it's the plaintiff and the plaintiff's lawyer and the defense lawyer. And sometimes maybe a plaintiff really wants to settle, and the attorney's just going, I don't want to settle. Well, everything, people trust their lawyers and everything goes through their lawyers. So do I have to respect the lawyer? Of course I do. And I do. I respect what the lawyer wants to do. But sometimes the plaintiff really wants to settle. And it's like, the lawyer doesn't want to do it, so we're not going to settle. I understand that. Sometimes the client doesn't want to settle and the lawyer really wants to settle. And maybe you've got a client who has a very idealistic view of the law. They think that there's some kind of supervening decision maker in the sky that's going to make sure the right thing happens, regardless of what the evidence is or what the witnesses say, or just that the right thing is going to happen as they understand it. That's not an uncommon experience with unsophisticated clients. If the lawyer's having a difficult time with that in the mediation, then even if it's in the client's best interest, the client may not recognize what's in their best interest. The mediator can help you with that. The mediator, is a second set of eyes, a second set of experience. And if the mediator is sensitive to that, you can never come in and try and beat a client down. They're going to feel like you totally don't understand them. And why'd we get this person anyway? And, you can't do that. But if the client is having real hard time on sort of coming to grasp with reality on what the case is about or the issues, a mediator can do that. So I don't do this frequently. I don't do that often, but sometimes if I sense that maybe there's a split between the attorney and her client, I might talk separately with the attorney, telling the client the attorney can come back in and fully explain everything we did, which is true. But taking the lawyer out separately and saying, what's really going on here or what's happening? And because sometimes counsel will give me an idea of what I might really need to understand that they just aren't comfortable necessarily talking about in front of their client. And I don't think that's not serving the client well or zealously representing the client. I think it's actually can be very significant because the clients sometimes just don't understand. And the attorney is really trying to do right by the client and do the best thing for the client. So sometimes that can be very effective, but if you need to, sometimes attorneys say that, can I talk with you just offline for a minute? And then whatever needs to be exchanged can be. A good mediator can really help you with that, with your client. I think it's a common experience to run across a mediator as counsel where you have a common vision of cases and values, and things just kind of click. You have enough of a common view about how things work that you can understand how the mediator works, and they respect the way that you work your case up. If you have that kind of a mediator who you feel like is doing a really great job, those can be super, super effective in your practice, where it's a nice working relationship. What I commonly find is, as I talk with counsel in different situations, maybe mediating with a first time, is it's very common for them to say, we're always looking for good mediators, which is an interesting comment because there's been, in the last 15 years, there's been an absolute explosion in the number of available mediators. There is nobody who's not going to be able to mediate because they can't find a mediator. I mean, that's just not a problem. There's a lot of mediators. So once you find someone that you click with, that's really worthwhile. If you find yourself in need of a mediator, maybe your preferred mediator retires or is out of the country, once COVID is over, whatever. there's some things just from a mediator's perspective, I think, that are super valuable. It's helpful to have someone who's quick on their feet, because a lot of times there's all this information that's just coming in really fast. It might be facts, it might be emotions, it might be personal things, personalities, comes in a lot. Someone who can make lightning quick assessments and then evaluate the legal arguments and marshal the facts in an understandable and a cogent way and then present them. I think it's super valuable to have someone who understands human nature and motivation. Again, it's the hearts and the minds that have to be convinced, and they make the difference on whether the case settles most of the time. And if a mediator understands what's moving people and what's important to them, at least at a really good level, then there's so much further down, moving the ball down the field to get towards resolution. It's super important to have a mediator that's approachable and credible and engenders trust. If people don't feel like they're getting the straight scoop from the mediator, they're just not going to be willing to share very much with that mediator. And then it's really hard. It really clamps down on the free flow of information. It's just going to be that much harder to settle a case. If it's low-hanging fruit, fine. It doesn't really make any difference. But if it's not, it's going to be really hard for that mediator to, it's really true. I mean, in litigation, as we practice for a lot of years, we realize that even though we're adversaries with opposing counsel, there's actually sometimes a fair amount of trust that goes on with your opposing counsel. No different with a mediator. The mediator is not opposing the parties, but there's still a lot of times a lot of trust that happens between the counsel and the parties and the mediator. And if you don't have someone you feel comfortable with that way, it's hard to really develop that. And then you may be less willing to move or to believe what the mediator is telling you about where the other side may really be. And a really key point is mediators are people, and people feel strongly about these lawsuits. It's about their money, it's about their property, it's about their family situations, it's about their pride, it's about their ego, and they're invested in it. And tempers can flare and emotions can spin up. And sometimes people get a little bit dug in, or they get hard-nosed, or I'm not going to do this, or they're just doing that, or sometimes they can even attack the other side, or sometimes they can even attack the mediator, and sometimes that can be counsel that can attack the mediator. So we all have the opportunity in mediation and litigation to decide where do we draw the line between our own ego and pride, as opposed to keeping our eye on the ball and getting the job done. And we all have to make that decision for ourselves. But mediators are people. And there can absolutely be a temptation as a mediator if someone's just being hard-nosed, completely intransigent, digging in because they feel vulnerable, they're threatened, they don't know where to go next, they've got their pride, whatever. There can be real temptation to say, well, fine, go ahead, take it to trial, fine, do that. And just throw the towel in. If you have a mediator who is willing to forego that and to forego, eat some humble pie, if they're getting attacked personally, and not take it personally, recognize the event for what it is and not take it personally, or let their own ego get involved so that they don't call the mediation just when someone's just being completely stick in the mud or aggressive or offensive or whatever. You're that much closer to resolving the case where there's a case that may actually be able to be resolved. So that's a very valuable point in difficult mediations. Two final points, and then we're done. And I'll take questions after. I'll stick around, but we're pretty much done. I like to use humor as appropriate. It lightens things up. It's a grueling process. I think there's a value in trying to keep the atmosphere light so people don't get worn out and just give up in frustration. We already talked about food. And that's the end. So thanks for being here. I don't see any questions in the Q&A, but I'll stick around. And if people have comments or questions they'd like to share, let me know. I'm here.
Thank you, Bob. Thank you very much. And I'm going to stop the recording.